So, hello friends, welcome back to my YouTube channel, that is Discourse Online Politics. So, in today's video, we are going to cover another question paper of UP Judicial Service Examination, and that question paper is of the year, that is the year of 2006. So, from the year of 2006, we are going to take the question paper and we will try to solve the questions of the law here. So, let's move towards the questions. So the first question which we are going to take here, and this is the question you all can see on the screen. The first question, that is from the Indian Evidence Act. A fact is said to be not proved. The options are when it is disproved, when after considering the matters not before it, the court believes that it does not exist. Another option, where a prudent man considers that the fact does not exist, when it is neither proved nor disproved. So, which is the correct answer when a fact is going to be said as a not proved? So, for that, you all need to refer section 3 of the Indian Evidence Act, where you will find that a fact is not proved when it is neither proved or not disproved. So, option is D is correct here. Moving to the next question. The statement in order to constitute a confession under the Indian Evidence Act must either admit in terms the offence or at any rate substantially all facts which constitute the offence. Now this statement which is given here, in which judgment it was said by the Privy Council. So you can see this statement belongs to the confession, that is in the Evidence Act section 25 onwards, where you can find the provisions with respect to the confession admissions. So from in which judgment of Privy Council it was observation was made. The options which are given here: John McKean versus Attorney General, Pakala Narayan Swamy, HHB Gill versus King Emperor, QE versus Abdullah. So my dear friends, you all know that the Pakala Narayan Swamy is the case in which this statement was made by the Privy Council. Moving to the next question, which section of the Indian Evidence Act 1872 deals with the civil matters? Section 23, Section 27, Section 53, Section 133. Now give your answer to the comment box, in the chat box, if you have the right answer. So the right answer is Section 23. So this is the correct answer. Okay. Next question. In which of the following cases it was held that Section 27 of the Indian Evidence Act of 1872 is an exception to Section 24, 25 and 26? So in which case it was held? The options which are given in the year of 2006, that is Pakala Narayan Swamy versus King Emperor, Inayatullah versus State of Maharashtra, State of UP versus Deoban Upadhyay, P. Kotaiya versus King Emperor. So now give the answer. This is very important question, and this question has been asked so many times in the UP judiciary as well as in the Bihar and some other states also. Now give the answers here, friends. The answer is Inayatullah versus State of Maharashtra. This is the right answer. Moving to the next question. The principle of promissory estoppel found its root. Now, the principle of promissory notes found its root. The options which are given here: A, it says that as an exception to the doctrine of consideration in the law of contract, as a rule of future consideration in the law of contract, as a rule of past consideration in the law of contract, and D, none of the above. So which is the right answer? Give your answer through the comment box. Okay, so my dear friend, this is about the promissory estoppel. So what you will find that the answer is here, as an exception to the doctrine of consideration in the law of contract. So this is the right option here. Moving to the next questions, question number 6. Now in the case of Palvinder Kaur versus State of Punjab, this case relates to which of the following? Whether it relates to confession, dying declaration, entries in the books of account, relevancy of judgments. I know that you all have read this case, so give your answer immediately. To which kind of the cases it belongs? So the answer is the confession. The A is the correct answer. Palvinder Kaur versus State of Punjab is a case which belongs to the confession. Now coming to the next question. The question number 7. The burden of proof in a suit or proceeding lies on that person who would fail if no evidence at all were given on either side. Now, this provision is contained in which section of the Indian Evidence Act? So, this is the statement with the provision with respect to the burden of proof. So, the options which are given here, that is the section 101, section 111, section 102, section 113. So, now give your answer immediately. Now, it says that it is like the shifting of the burden. So, a person upon whom the liability is there to prove, if he fail to prove, then he will lose the case or the proceeding. So, obviously, the answer is that is section 102 of the Indian Evidence Act. Okay. Moving to the next question. The principle that possession is a prima facie proof of ownership is provided under which section of the Evidence Act? Okay, so possession is a prima facie proof of ownership. In which section it has been held? So the options which are given here: section 109, section 111, section 110, and section 112. So which is the right answer? Give your answer through the comment box. I am waiting for your response here. Give your answer. So the right answer is here, section 110. It says that the possession is a prima facie proof of ownership. That is the Evidence Act of section 110. Coming to the next question. Question number 9. In which one of the following cases the Supreme Court held that the confession of an accused are very weak evidence and no conviction can be based solely on such confession? So in which case the Supreme Court had made this kind of statement? The options which are given here, that is Nathu versus State of UP, Ram Prakash versus State of Punjab, Kashmira Singh versus State of MP, and none of the above. So in which case the Supreme Court says that confession is a very weak kind of evidence? So give your answer through the chat box. I am looking for your responses through the chat box. Yes, the right answer is the Kashmira Singh. Moving to the next question. Which of the following does not find a mention as showing state of mind under section 14 of the Evidence Act? So which is not mentioned in section 14 of the Evidence Act? Ill will, motive, good faith, negligence. So which is correct? Whether A is correct, B is correct, C is correct, D is correct? Give your answer to the chat box or comment box. Write your answers in that. And just I am waiting for your response here. So which is the option which is not mentioned in the section 14? So my dear friends, you all know that section 14 says about ill will. It says about good faith also. It says about negligence also. It does not say about the motive. So the answer which is going to be here, that is the motive. Coming to the next question. A witness who is unable to speak gives his evidence in writing in the open court. Evidence so given shall be deemed to be. So a person who is not able to speak, whether that kind of evidence would be considered, which kind of, whether primary evidence, secondary evidence, documentary evidence, oral evidence. So my dear friends, you all know that the person who is not able to speak, these are people are being called as a dumb evidence witnesses. So therefore, what kind of evidence it is going to be considered? This is a very popular question, and it is coming so much number of times in in the examination as well. So the what kind of the evidences would be given it, consider it? So this would be considered as a oral evidence. So this would be considered as a oral evidence. Coming to section question number 12. Provision have been made under certain sections of the Indian Evidence Act regarding relevancy of certain facts. Match the entries of list 1 and list 2 below and write the correct answer using the codes. So there is a matching of this one. So we have to find the correct matching here. So opinion of handwriting, section 22, statement of relevant fact by a person who is dead or cannot be found, section 47, previous good character in criminal cases, 32, oral admission as to the contents of document. So now just see which sections is dealing with the facts which are given in the list 1. So we have to do a matching here. So just see here, I am just zooming in so that you can see very carefully here, and just give me answers to the chat box. Immediately give your answers, my dear friends. Yes, the answer is this one, A. 2, 3, 4, 1. Now, why it is 2, 3, 4, 1? Because opinion of handwriting expert belongs to section 47. Then state of relevant fact by person who is dead or cannot be found, it belongs to the 32. Okay. Previous good character in criminal case, it belongs to the section 53 of the Evidence Act. And oral admission as to content of document, it belongs to section 22. So this is how you can find that the correct answer is here A. This is how you can find. Coming to the next question, legitimacy of child born during valid marriage is presumed under which provision of the Indian Evidence Act? Under which provision of this section of the Indian Evidence Act it is going to be declared as a valid one? So options which are given here, section 115, 114, 112 and 113. So now give your answer immediately to the comment box. This is very easy question and very important question for the prelims as well. Waiting for your response here. Yes, the right answer is section 112 of the Indian Evidence Act. Okay. Coming to the next question. A barrister is instructed by an attorney or vakil that an important witness is a dacoit. This is a reasonable ground for asking the witness whether he is a dacoit. This illustration is based on which section of the Indian Evidence Act? The options which are given here, section 149, section 153, section 147, section 145. So give your answer in the comment box. I am waiting for your response here. Yes, give the right answer. Yes, the answer is section 149. Okay. Which of the following is not correctly matched here? So we have to see which is not correctly matched here. Okay. Now let's see. Matrimonial communication, it says that it is 122. Official communication 124. Professional communication 126. And the confidential communication with legal advisor 127. So which is not correctly matched here? So just go to this, you will find that this one, the confidential communication with the legal advisor is not correctly matched. The rest are the correctly matched here. Okay, they are correctly matched, but this is not correctly matched here. Okay. Now for this, section 129 is there. Confidential communication with the legal advisors is given under section 129 of the Indian Evidence Act. Okay. Coming to the next question, that is the decree holders, and this is a question from CPC. Decree holder means any person in whose favor a decree has been passed or an order capable of execution has been made. This definition of the term decree holder has been given under which section of the CPC? So section 2, you all know that it is about the definition clause. The options which are given here, section 2 clause 2, section 2 clause 3, section 2 clause 4, section 2 clause D. Now give your answer immediately through the chat box, through the comment box. I am waiting for your response here. Yes, just give me answer. Yes, the right answer is section 2 clause 3. It defines about the decree holder. Coming to the next question, rejection of plaint is mentioned under which order and rule of the CPC? So options which are given here, option A, order 7 rule 11, order 6 rule 13, order 7 rule 12, order 8 rule 4. So now give the answer immediately through the comments. I am waiting for a response. So the rejection of plaint is mentioned under the order 7 rule 11. So this is the correct answer. Coming to this one, here we have to find out which combinations are not correctly matched. So we have to identify this one which is not correctly matched here. Okay. Now the options which are given here, execution of decree, section 77, letter of request, section 82, letter of representative, section 50 of the CPC, section institution of suits, section 28 of the CPC. So we have to see which is not correctly matched here. So give your answer immediately. Yes, this one, which you can find here, that letter of request, it is not in section 82 of the CPC. So what you find that we have to see which is the correct answer, which is not the correctly matched. So this is not correctly matched. Then execution of decree, it is not in section 77 of the CPC. And then institution of suits, it is not in the section 28 of the CPC. So therefore the answer which is going to come here, that is the 1, 2, 4, that is the B. Okay, coming to the next question, which one of the following case is not second appeal, is on second appeal, sorry, which one of the following case is on second appeal, इसमें से कौन सा केस second appeal पे है, we have to see here. The options which are given here, option A, Madan Lal versus Bai Krishna, B, Sudhir Ji Angur versus M Sanjeev, C, Udan Singh versus Darayo Kumar, Harshad Chiman Lal Modi versus DLF Universal Limited. So which is the which case is based on second appeal? Just give your answer. I am waiting for your response here. And the answer is the Madan Lal. In the Madan Lal versus Bai Krishna, this case belongs to the second appeal. Coming to the next question, that is Dasti summons. So Dasti summons for service on the defendant can be given to the plaintiff under which order and rule of the CPC? The options which are given here, order A, it says order 5 rule 9A, order 5 rule 9C of CPC, order 6 rule 7 of CPC, order 6 rule 6 of the CPC. So now Dasti summon is a kind of the question which is oftenly coming in the prelims examinations. Okay, so now give your response to the comment box. Yes, the right answer is order 6 rule 7 of the CPC. It talks about the Dasti summons. Coming to the next question, section 115 of the civil CPC provides for the following. So which kind of the provision has been mentioned under section 115 of the CPC? Now the options which are given here, that is the reference, review, revision, appeal to the Supreme Court. Now this is very simple question and easy question, and give your answer immediately. Section 115 of the CPC talks about what kind of the provisions? I am waiting for your response here, my dear friends. Give your answer through comment box. Yes, the right answer which you can find here, it belongs to the revision. I know that you know the answer. Please give your answers through the comment box immediately so that we can cover the more questions here. Okay, coming to the next question which is going to cover here, that is the order 23 of the CPC applies to the following. So whether it belongs to the withdrawal of suits, option B, appeals, option C, execution proceedings, option D, all the above. So give your right answer here. Order 23 of the CPC belongs to which kind of the provisions? Give your answer immediately here. Yes, the answer is withdrawal of suits here. Coming to the next question, under which explanation of section 11 of CPC constructive res judicata has been explained? So under which provision of which explanation of section 11 of CPC it has? So options which are given in explanation 1, B option explanation 2, C option explanation 3, and D option explanation 4. Give your answer immediately through the comment box so that we can find that the constructive res judicata. Yes, you know that the answer, I know this. So give your answer to the comment box. I am waiting for your response here. The options which are here, that is the correct option. That is the explanation 4. It says about the constructive res judicata. Okay, coming to the next question. Section 18 of the CPC provides for place of institution of suits in respect of immovable property where the property is situated in the jurisdiction of one court. Place of instruction of suits in respect of immovable property where the property is situated in the jurisdiction of different courts. C, place of institution of suits in respect of immovable property where the local limits of jurisdiction of courts are uncertain. And D, all the above. So give your answer. I am waiting for your response. So section 18 is about the place of suing. Okay. Now this section 18 belongs to this answer, that is when there is uncertainty, there is no uncertainty that where this no property, immovable property belongs, then in that case section 18 helps to file the suit. Coming to the next question, a decree may be executed by whom? Whether it can be executed by Tehsildar, collector, district judge, either by court which passed it or to which it is sent. Give your answer. It is very easy question, and give your answer immediately. Yes. Which is the right answer? Waiting for your response here, my dear friends. Yes, the right answer is D. The decree may be executed either by the court which has passed it or the court to which it has been sent for the execution. So for this, you can refer section 28 of the CPC. Okay. Coming to the next question, objections as to place of suing shall be allowed in the court of first instance is the essence of which kind of the provision? Section 21A of CPC, section 20 of the CPC, section 22 of CPC, section 21 of the CPC. So which provision of CPC says that the place of suing shall be allowed in the court of first instance? So give your answer immediately through the comments. I am waiting for a response here, my dear friends. Yes, the answer is section 21 of the CPC. Coming to the next question, the period of limitation within which defendant shall submit his written statement is ordinarily within the options which are given here: 60 days from service of summons, always 90 days from service of summons, 30 days from service of summons, or 90 days if allowed by the court. The last option which is given here, that is the 15 days from the service of summons. So which is the right answer? Give your answer through the comments. I am waiting for your answer. The period of limitation within which the defendant shall submit his written statement is ordinarily. So जब कोई एक्सेप्शन नहीं है तो डिफेंडेंट को कितने दिन के बीच में जो है रिटन स्टेटमेंट को सबमिट करना पड़ता है? गिव योर आंसर हियर. ओके. यस, द राइट आंसर इज दिस सी, and it refers to order 8 rule 1 of the CPC. Okay. Coming to the next question, a person may sue a foreign state with the consent of the state government, only with the consent of the central government, with the consent of central or state government, with the consent of the president of India. So which is the right answer? A person may sue a foreign states. अगर कोई व्यक्ति जो विदेशी राज्य को अगर सू करना चाहता है, उसके खिलाफ वाद लाना चाहता है, तो कौन ला सकता है, किसके कंसेंट से वाद ला सकता है, सूट फाइल कर सकता है? यस, द आंसर इज इट इज विद द कंसेंट ऑफ ओनली ऑफ सेंट्रल गवर्नमेंट. फॉर दिस यू कैन रेफर दिस सेक्शन 86 of the CPC. Okay. Coming to the next question, certain topics under the CPC are described hereunder in list 1, while their sections, orders, numbers are mentioned in list 2. Match the entries of list 1 and list 2 and write the correct answer using the codes below. So we have to do the matching here with the correct coding here. So you can see in list 1, affidavit, arrest before judgment, commission to examine witness, sued by indigent person. In list 2, order 26, order 33, order 19 and order 38 has been given. So which is the right answer here? Just I am zooming in so that you can see the right answer from here. Just I am waiting for a response here, my dear friends. Yes, so now you can see here the affidavit provision has been given under the order 19. Okay, arrest before judgment has been given in order 38. Commission to examine witness has been given under the order 26. Sued by indigent person has been given under the order 33. So therefore the answer which is correct here, 3412, that is the C. Coming to the next question, which of the following determination does not come under the definition of the decree? So when you give a definition of decree, which is not a factor for that, for determination. Okay, the first one is, the first option is that an adjudication which conclusively determines the rights of the parties with regard to some of the matters in issue before the court. B. Rejection of plaint. C. Determination of any question under section 144 of the CPC. Fourth, dismissal of a suit for a default. So which is not coming within the definition of the decree. So give your answer here. I am waiting for your response here. Yes, this is the dismissal of suit for default is not a part of the decree, and for this definition of decree you can refer the section 2 clause 2 of the CPC. This is also one of the MCQ, under which provision of this CPC the decree has been defined. Coming to the next question, the amendment of the Transfer of Property Act 1882 in the year 2002 amended, and in which year it was amended? The TPA. Okay, now which provision has been amended in 2002? The options which are given: section 100, section 108, section 106, section 110. So which provision of the TPA was amended in the year of 2002? So give your answer in the comment box. I am waiting for your response here, my dear friends. So give your answer immediately. Yes, so the right answer which is here, that is section 106 of the TPA here. Next question, which one of the following is not an essential element for a valid transfer of property? Competent transferor, transferable property. The next option which is given here, let's see this one. That is C. Transferee may not be competent to take the transfer. Object of transfer must be lawful. So which is the options which you have to find here? The is not an essential for the transfer of property here. So give your answer here immediately. For transfer of property, which is not a essential element. I am waiting for a response here, my dear friends. Whether transferee may not be competent to take the transfer. Yes, this is the not essential. Okay, coming to the next question of the TPA, which of the following is not correctly matched here? Rule against perpetuity, conditional transfer, vested interest, contingent interest. So which is not correctly matched here? Now identify. I am waiting for few seconds here for a response. So just give your answers immediately here. So the which is not correctly matched. So rule against perpetuity is in the section 14. So it is correct. Vested interest is given in the section 19. It is correct. Contingent interest is in section 21. It is correct. But the conditional transfer is not in the section 24. So therefore this is not the correctly matched here. So B is the correct answer, which is not correctly matched here. Coming to the next question, section 41 of the TPA of 1882 is the statutory application of the law of estoppel. Whether this statement is true, false, partly true, or none of the above. So give your answer here. Whether it is statement is true? Yes, this statement is true. Coming to the next question, which of the following cases is related to the right of redemption? So Stanley versus Wilde, Knox versus Rice, Krenger versus New Patagonia Meat and Cold Storage Company Limited, or all of the above. So give your answer. I am looking for your answers here, waiting for your response here. To which case belongs to redemptions? So all the cases which are given here, they belong to redemption. So therefore all the above cases are correct. They are talking about the redemption here. Coming to the next question, which of the following sections of Transfer of Property Act can now contain exception to the maximum nemo dat quod not habet? Okay, so now options which are given in section 41 and 42, section 43 and 44, section 41 and 44, section 41 and 43. So which provision of the TPA is an exception to the maximum of nemo dot quod not habet? So give your answer here. I am waiting for your answer. The answer is section 41 and 43. Okay, coming to the next question, a doctrine which requires the transferor must deliver the subsequently acquired property to the transferee who acted upon his false representation and did harm to himself by paying money for what he could not get it is called, whether it would be a rule against unjust enrichment, implied consent, feeding the grant by estoppel, or doctrine of substantial compliance. So give your answer here. Which doctrine says? Waiting for your response here. So it is feeding the grant by the estoppel. Coming to the next question, that is from section 37 of the TPA here. Section 37 of the TPA on right to proceeds of revenue compensation on acquisition is based on the options which are given here, that is doctrine of election, doctrine of substituted security, or doctrine of marshalling, or doctrine of contribution. So which is the right answer? Section 37 of the TPA, which talks about the right to proceed of revenue compensation, it is based on which doctrine? Okay, give your answers here, whether it is on the doctrine of election, doctrine of substituted security, doctrine of marshalling, or doctrine of contribution. So the answer is here, you are correct, that doctrine of substituted security. Okay. Coming to the next question, rule against perpetuity is not applicable to a case. The options which are given here: property is transferred for the benefit of the public, interest in property is created generation after generation, transfer of property purport to be effective beyond minority of ultimate transferee who is not in existence at the date of transfer, contingent interests are created by the transfer. So rule against perpetuity is not applicable. In which case? Give your answer. I am waiting for your response here. So the answer is property is transferred for the benefit of public. So this is not the right answer. The rest are the correct. So the options A is not applicable. Rest are applicable to the rule against perpetuity. Now coming to this next, in case of gift, the donee dies before the acceptance. Whether in that case the gift is going to be valid, void, voidable, or the court has to decide. So give your answers here. I am waiting your answer. Yes, the gift is going to be void in case of donee dies before the acceptance. Next question, the doctrine of election is applicable to whom? Hindus, Christians, Muslim, or all the above. So give your answers here. I am waiting for your response here. Yes, doctrine of election belongs to everyone. So it is all of the above. Next question, the foundation of doctrine of election under the Transfer of Property Act 1882 is that a person taking a benefit of an instrument, the options which are given here: must bear the burden, must not bear the burden, burden is not the subject of election, and D, none of the above. So which is the right answer? Just give your answer. Yes, when a person is going for doctrine of election, he must bear the burden as well. So this is the right answer here. Coming to the next question, that is A lets his house to be for 5 years, B underlets the house to C at monthly rent of rupees 1000. The 5 years expires, but C continues in possession of the house and pays the rent to A. The lease of C is whether it is renewed for a further period of 5 years, is renewed from month to month, is terminable at any time, is renewed from year to year. So what is the right answer? Just give me your answer here. Here you can see here the question. Yes, it is renewed from month to month. This is a one illustration which is also in the TPA. Okay, coming to the next question. Remedy of foreclosure is available in which one of the following mortgage? Whether it is in the usufructuary mortgage, mortgage by conditional sale, single mortgage, or English mortgage. So remedy of foreclosure is available in which one of the following mortgage? Just give your answer. This is very very oftenly being asked in the prelims examination in all the states. Yes, the answer is mortgage by conditional sale. Moving to the next question, that is question number 45. Again, it is the matching of list. So we have to do a matching of list here. So just see this list 1 and list 2. You can find that List 1 talks about the doctrine of election, subrogation, doctrine of holding over, waiver of forfeiture. List 2 is about certain sections, section 112, section 92, 35, 116. So I am zooming in so more so that you can see the list 1 and list 2, and then you can do the matching. So I am giving few seconds to you, 30 seconds to you to get the right matching here. So waiting for your response here. Yes, give me your answers. I think you all have understood which is going to be rightly matched here. So the answer which is here, that is A. Why it is A? Because A, doctrine of elections, belongs to this section 35. Subrogations belongs to the section 92. Doctrine of holding over belongs to the section 116. And waiver of forfeiture, it belongs to the section 112. Therefore, this is the right answer. Okay. Coming to the next question. In every statute, mens rea is to be implied unless the contrary is shown. So, in which case this kind of the statement was made? So, this is a very important question, and it has been asked in so many times in the various other states also. So now give the answers here. I am waiting for response. The options which are given here: Siraj versus D. Rudgen, R versus Dudley versus Stephen, Harding versus Prince, R versus Prince. So in every statute, mens rea is not to be implied unless the contrary is shown. Okay, is to be implied unless the contrary is shown. The answer is Siraj versus D. Rudgen. Coming to the next question: which of the following pair is not correctly matched? So see, I am zooming in, which is not correctly matched here. Okay, mens rea, necessity, insanity, intoxication, and on the opposite side you can see R versus Prince, DPP versus Baird, McNaughton case, Basudev versus state of Pepsi. So which is not correctly matched here? Just give me the answer here immediately. I am looking for that. Yes, mens rea belongs to the R versus Prince. Insanity is about the McNaughton case. Intoxication is about the Basudev versus state of Pepsi, and this is not the correctly matched. Necessity does not belong to DPP Baird case. So therefore, this is not the correctly matched, and the answer is here B. Okay. Next question is: in which case the Supreme Court has struck down section 303 of the IPC? So the options which are given: Machi Singh versus state of Punjab, Bachchan Singh versus state of Punjab, Santa Singh versus state of Punjab, Mithu Singh versus state of Punjab. So in which case the Supreme Court said that the section 303 is unconstitutional. So give your answer. This is a very popular case, and the case is Mithu Singh, in which the court has said that section 103 is unconstitutional. So the option is Mithu Singh. Okay. Next question: which one of the following statement is not defamatory? Okay. So the first statement, A says about a woman B that she has paramour wherever she goes. The we have to say which is not defamatory. Okay. A publishes a photograph with a false caption Gunda. A says, I am not surprised that B's book is foolish, for he is libertine. For he is a libertine. And the next is A in the course of police investigation says B may be involved in the murder of D because both of them were bitter enemies. So now which is not a defamatory question? So of course this one, because it is a kind of a statement which is made in the police investigation and without any kind of the intention. This kind of statement can be made here. Coming to the next question, and this question says about assertion and the reason. So assertion says that homicide is the killing of a human being by another human being. Homicide is always unlawful. Okay. Now let's see whether assertion has support from the reason or not. So give your answer here. I am waiting for a response here. Just waiting. Okay. So now see here. Homicide is not always unlawful. Okay. In certain cases, homicide is also permissible when you have a right to private defense in case of property and all this. So in that case, homicide is lawful also. So therefore, what you find that A is true, but R is false. Okay. Coming to the next question, assault in order to outrage the modesty of women is punishable under which provision of the IPC? Section 363 of the IPC, Section 509 of the IPC, Section 511 of the IPC, Section 354 of the IPC. So now just give your answer through the chat box, comment box. I am waiting for your answer, and this is very known and very famous question which is oftenly being asked for the mains as well. Sometimes in mains also they are asking questions. Yes, the answer is section 354 of the IPC. Coming to the next question, and this question says that B and C were on the railway platform. B had taken a ticket from Allahabad to Delhi. B, an illiterate woman, handed over the ticket to C in order to ascertain whether C had a right ticket. C, under the pretense of returning the ticket to Delhi, substituted it for the ticket of shorter journey and returned that as B's ticket. In this case, C is liable for what? Cheating, criminal misappropriation, theft, criminal breach of trust. Give your answer. कोई रास्ते में जा रहा था, उसने टिकट वो पढ़ नहीं सकता था, उसने टिकट दूसरे व्यक्ति को दिया पढ़ने के लिए, भाई कहाँ देखिए टिकट सही है या गलत है, उसने वो टिकट को बदल के उसको जो छोटी जर्नी के लिए टिकट दे दिया और वो टिकट अपने पास रख लिया. तो क्या ये जो है कौन सा ऑफेंस होगा आईपीसी का यहाँ पे? गिव योर रिस्पॉन्स हियर. So you can see it is about the criminal misappropriation because he took the property for his own use. So therefore it would be a case of criminal misappropriation. Coming to the next question, the principle of proximity of crime under the criminal law is irrelevant while deciding the liability for the offense of. So the proximity of crime under criminal law is irrelevant in deciding the offense, which kind of theft and dacoity, culpable homicide and murder, kidnapping and abduction, abatement and conspiracy. So proximity का जो प्रिंसिपल है वो अप्लाई नहीं होगा इन किस ऑफेंस के मामले में. So just go to the options and give your answers here. So yes, it is going to apply in the case of abatement and the conspiracy. Okay, coming to the next question. A commits theft on the property in the possession of B, and while committing this theft, he has a loaded pistol under his garment kept for the purpose of hurting B in case B should resist. The offense committed by A is defined under which section of the Indian Penal Code of the IPC? Whether it is section 382, section 379, section 390, section 381. So give your answer through the comments. I am looking for your options, waiting for your response here. So give your answers here immediately. Yes, this this belongs to section 382 of the IPC. Coming to the next question, IT Act 2000 has made amendments in which provision of the IPCs? So the options which are given: section 463 of the IPC, section 466 and 477A of the IPC, 463, 467, 477A of the IPC, section 462 of IPC only. So the IT Act has made amendments in which section of the IPC? Just give your answers. I am looking for your answers. I am waiting for your answers. So give your answers. Yes, the right answer is C. So the IT had made some changes in these sections of the IPC, section 463, 466 and 477A of the IPC. Coming to the next question, A promises to marry B, his student, and induce her to cohabit with him. He has given her a false assurance of marriage and also fraudulently gone through certain ceremonies of marriage, making B believe that she was a lawfully wedded wife of A. Later, A refused to recognize her as his wife. What offense has been committed by A? So the options which are given here: rape, adultery, outraging modesty of women. A has committed no offense. So give your answers here. I am waiting for a response. Yes, this would be a case of rape. Okay, you all have heard dissent judgments also. A police officer tortured B in order to induce B to confess that he committed a crime under which section of the IPC. The police officer is guilty of an offense. So, if a police officer is doing a torture on someone, and in order to induce to confess his to commit to that he has committed a crime, which kind of the provision of the IPC will apply here? Whether it would be section 325, 326, 328, 330. फटाफट आंसर करके बताएं. आई एम वेटिंग फॉर योर रिस्पॉन्स हियर. Yes, this will go to the section 333 of the IPC. So this is the right answer. Coming to the next question. A picked up revolver and believing it to be loaded, pulled the trigger with the criminal intention of shooting B dead. Fortunately, the revolver was not loaded and B escaped unhurt. A has committed the offense of. Which kind of offense has been committed by A? The options which are given: murder, attempt to murder, culpable homicide not amounting to murder. A has committed no offense. So which is the right answer here? Give your answer to the comments. Yes, this is the attempt to murder. Coming to the next question. Which one of the following combinations are not correctly matched? So the options which are given here: Mehboob Shah Emperor versus Common Object, State of Maharashtra MS George versus MS George, that is the mens area, and then Director Public Defense of Prosecutor versus Bayer Insanity, and the last one P. Ratinam versus Union of India, that is dowry death. So which is not correctly matched? So we have to see the codes here. So just see the options here and let me know which is not correctly matched here. So what you find that, my dear friend, this is the right answer. Why this is? Because P. Ratinam belongs to the suicide and DP versus does not belong to the insanity. Okay, and this the first one, Mehboob Shah versus Emperor, it does not belong to the common object. So these are the incorrect match. So the options which is to be here correct, that is 1, 3 and 4. Coming to the next question. Match list first with the list 2 and select the correct answer by using the codes given below the list. So list 1 and list 2 has been given. We have to do a matching here and see which is the correct. So in the list 1 you can find the offenses like the criminal breach of trust, public nuisance, dacoity with murder, assault with intention to outrage modesty of women, and in list 2 you can find the provisions of the IPC, section 396, section 354, section 405, section 268 of the IPC. So just show me which is the correct match here. Waiting for your response here. Whether which is the correct match. So if you see this here, you can see criminal breach of trust, which is there. It belongs to the section 405. Okay. Public nuisance, it belongs to section 268. Dacoity with the murder, it belongs to section 396. And assault with intention to outrage modesty of women, it belongs to section 254. So the right answer is here, this one. That is the D, 3412. Coming to the next question. Which one of the following is not provided in the section 4 of the Contract Act? Section 4 of the Contract Act किसके बारे में बात नहीं करता है? Now the options which are given here: communication of a proposal, communication of acceptance, communication of revocation, revocation of proposals and acceptance. So which provision is not dealt under the section 4 of the Contract Act? So just give your answer to the comment box. Yes, the answer is revocation of proposal and acceptance. So revocation of proposal and acceptance is not provided in section 4 of the Contract Act. Okay. Coming to the next question. B says to A, if you do not deny it, I shall assume that the horse is sound. A says nothing. Here A's silence is equivalent to speech. This illustration is based on which section of the Contract Act? Whether it is section 17, 18, 19 and 20. ये क्वेश्चन का आंसर तो आप लोग को फटाफट आना ही चाहिए, आई होप, क्योंकि अब तो एग्जाम आने ही वाला है यूपीजीडीसी का। यस, दिस इज सेक्शन 17। कमिंग टू द नेक्स्ट क्वेश्चन, wagering agreements are whether they are void but enforceable by law, void and not enforceable by law, voidable and illegal but enforceable by law, voidable and illegal but not enforceable by law. So the wagering agreements are like what kind of the law, kind of the a contract? Just give your answer here. I am waiting for your response here. Yes, this is void and not enforceable by law. So for that you can refer to section 30 of the Indian Contract Act as well. Moving to the next question, question number 64. A proposal is revoked. When a proposal is going to be revoked? Only by the death or insanity of the proposer itself, by the death or insanity if the fact of the death or insanity comes to the knowledge of the acceptor, by the death or insanity of the proposer if the fact of his death or insanity comes to the knowledge of the acceptor before acceptance, and D, none of the above is correct. So give your answers here. I am looking for your answers. A proposal is going to be revoked. Yes, the proposal will be revoked when by the death or insanity of proposer if the fact of his death or insanity comes to the knowledge of the acceptor before his acceptance. So this is how you can find that. Now next question, which one of the following combination is correctly matched? Okay, so we have to see which is correctly matched, and then we have to answer to the codes here, which you can see here. Okay, so you can see on the left side responsibility of finder of goods, surety liabilities, sub-agent, bailiff's particular lien. On the other side, opposite right side, you can see the section 71, 128, 191 and 171 has been mentioned. So which is correctly matched here? So just give your answer here. I am waiting for a response here, which is correctly matched here. So my dear friends, you can see responsibility of the finder of goods, it belongs to the section 71. Okay, then if you just go to this, you will find that surety liabilities belongs to the section 128. So it is correctly matched. Then sub-agent in section 191, but the bailiff's particular lien is not in the section 171. So this is the right answer. All these options are correctly matched. Okay, going to the next question, which of the following is the correct meaning of the privity of contract principle? Okay, the options which are here, what is the meaning of privity contract? Parties must maintain the privity of contract. Main objective of the contract must be maintained. Only parties to contract may sue on it. Only the parties know in which circumstances the contract was made. So just go to this and give your answers here. The privity of contract means only parties to contract may sue on it. Going to the next question, that is the matching the list. Okay, and we have to see again. So you can see on the left side the cases which are given: McGregor versus McGregor, Weeks versus Tablet, Henderson versus Stevenson, Curie versus Misha. On the right side you can find the provisions like general provisions, intention to contract, consideration and reasonable notice. So now give your answers, which is the correct match here, which code is giving the right answer and giving the right matching here. So give your answers. I am looking for your response here. So what you can see here, so McGregor versus McGregor belongs to intention to contract. Wig versus Tablet belongs to general proposal. Henderson versus Stevenson belongs to reasonable notice, and this one Curie versus Misa, it belongs to the consideration. So therefore the option which is here correct, that is the 2143, and that is the B. Okay, moving to the next question, that is of the contract. The word consortium ad item means no agreement can have more than one meaning: to agree in the same way, to agree on the same thing in the same sense, to agree for different objects in the same sense. So which is the right answer? So for that the answer is to agree on the same thing in the same sense. So this is, you can find that the definition of the consent under the Contract Act. So now coming to the next question, which one of the following does not amount to fraud? So among this illustration, which is not a case of fraud? Suggestion as a fact of that which is not true by one who does not believe it to be true, entire concealment of fact, a representation made without knowing it to be false, honestly believing it to be fraud, a promise made without the intention of performing it. So which is the, though you can see that is not a case of the fraud here, we have to find. So you can see here the C, because a representation was made without knowing it to be false, honestly believing it is to be true. So there is honest belief, and therefore it is not a case of fraud. Going to the next question, a right to sue on quantum merit arises when a party has fully performed the contract. The option B, when a party partly performs the contract and is discharged by the other party. C, when a contract is discharged by the impossibility of performance. And D, when a contract becomes illegal. So the right to sue on quantum merit arises when? So give your answers here. I am waiting for your response here. So give your answer from the comment box. फटाफट आंसर कीजिए. क्वांटम ऑफ मेरिट कब अराइज होता है? Yes, the answer which you can see, when a party partly perform the contract and is discharged by the other party. So the B is the correct answer. Going to the next question, change of the nature of the obligation in a contract is known as. So when the nature of the obligation is going to change in contract, it is being called as what? Rescission, novation, renovation, alteration. When the nature of obligation is going to be changed, so what kind of the contract it would be called here? So give your answers. Yes, this would be a case of the novation. Okay, because the nature of the contract has been, obligation of the nature has been changed here. Coming to the next question, the judicial basis of quasi-contractual obligation can be explained through the principle of the options which are given here: voluntary benefits, just and reasonable solution, unjust enrichment, and the indefensious assumption. So give your answers here, waiting for your response. Yes, the quasi-contract is like that. It is based on the unjust enrichment. So on this principles, this is a quasi-contract is going to be based. The next question, the principle of assessment of damages for breach is given in which case? The options which are given: Hadley versus Baxendley, Scarf versus Jordan, King versus Horde, Hyde versus Wrench. So under which provision case this has been dealt? Just give your answer here. I am waiting for response. This is the King versus Horde. So this is the case which you can, this is the case which you can find here. That is the Hadley versus Baxendley. This is the because it was about assessment of damages for breach. So therefore this is the right answer, and therefore I need to change this one. Just a second. So the right answer here is, because it is about the assessment of damages for breach, so the answer is Hadley versus Baxendale. Okay. Coming to the next, which statement is wrong regarding agency under the Indian law of contract? Okay. Now see the options which are given. Principal should be competent to contract. Principal should be competent to contract. The authority of agent may be expressed or implied. Consideration is not necessary to create an agency, and guardian of minor can appoint an agent for him. So which is wrong statement? We need to identify here. So what do you find that? The answer is consideration is necessary to create an agency. So this is the wrong regarding the agency, and for that you can refer to section 185 of the Indian Contract Act. Now the next question, the case of Hoster versus D law tour deals with which kind of a case? Whether it deals with quasi-contract, doctrine of promises stoppage, anticipatory breach of contract, or the quantum merit. So give your answers here, waiting for your response. Yes, this case belongs to the anticipatory breach of contract. Okay. Coming to the next question, additional chief judicial magistrates may pass a sentence of imprisonment extending up to. Now this is question from the CRPC. Okay. So from this question from CRPC is going to start. So the chief judicial magistrate, that is CJM, can impose the imprisonment of how many years? So the options which are given: 5 years, 7 years, 3 years, and 10 years. So the right answer which is here, give your answers, waiting for your response here. Yes, just 7 years. So for that you can refer section 29 of the CRPC. Okay. Going to the next question of CRPC. Which provision of CRPC resembles with habeas corpus writ? Section 91, Section 97, Section 93, Section 96. Okay. So now give your answers, options here. That is, the answer is Section 97 of the CRPC. Going to the next question. Which section of CRPC 1973 applies when the officer in charge of police station receives information that a person has committed a suicide? Okay. So which section of CRPC talks about this kind of the provisions when information has been received in the police station from the officer in charge of police station with respect to committed suicide? So which provision of the CRPC will apply? Give your options here, answers here. Section 174, 181, 154 and 157. So give your answer immediately. Yes, the right answer is section 174. Coming to the next question. Under which section of the CRPC inherent powers can be exercised by the High Court? So which provision of the CRPC talks about the inherent powers of the High Court? The options the options which are here: 482, 483, 484, 480. So give your answers here. I am waiting for a response. Yes, the answer is section 100, section 482. Okay, it says about the inherent power of the High Courts. Coming to the next question. Which one of the following offences has not been enumerated under section 110 of the CRPC, which empowers an executive magistrate to require such person to show cause why he should not be ordered to be execute a bond for his good behavior? So which one of the following offence has not been enumerated? Drugs and Cosmetic Act, Dowry Provision Act, Foreign Exchange Regulation Act, Untouchability Offences Act. So give your answers here. I am waiting for your response. Sir, yes, you are right here. The Dowry Provision Act is not included in the section 110 of the CRPC. Going to the next question. The chapter of plea bargaining is added to the CRPC. This is very popular question in the prelims. So the chapter of plea bargaining is added by CRPC by which provision? Just give your answer here. I am waiting for a response. So CRPC Amendment Act 2005, CRPC Amendment Act 2005, Act number 2 of 2006, and then CRPC Act 2006, Criminal Law Amendment Act 2003. So give your answers here. Yes, the answer is Criminal Law Amendment Act 2005, Act number 2 of 2006. So be careful in UPGDC. Sometimes they ask questions with reference to Amendment Act and also with the Act number here. Okay. Going to the next question. Which one of the following is not correctly matched here? Okay. We have to see which is not correctly matched here. So you can see I am zooming in so that you can see the question here. Okay. So what you can see: police to prevent cognizant offense, it is correctly matched. Power to arrest to prevent the commission of cognizant offense, it is correctly matched. Power to certain armed forces officer to dispense assembly, it is correctly matched. And the last one, arrest by magistrate, is section 45. So you can see here this is not correctly matched because it belongs to section 44 of the CRPC. This is the answer here which is correct here. So it is not correctly matched here. Okay. Coming to the next question. Which one of the following is correctly matched here? Okay. Now here we have to see which is correctly matched. So information in cognizant offense, section 154. Yes, this is correctly matched. You all know that. So we need not to see the others provisions here. Okay. We are skipping this one. Okay. Coming to the next. That is, which one of the following combinations are not correctly matched? So many questions are being asked in the UP judiciary for matching also. So you all need to know the provisions and their sections also. Remember. So the which is not correctly matched here. So we have to see the courts also. Anticipatory bail, summary dismissal of appeal in case of acquittal, reference to high courts, section 437, section 384, section 376, section 397 of the CRPC. So we have to see which is not the correctly matched here. Okay. So what you can find that the anticipatory bail is not in the 437. So this is not correctly matched. Okay. Appeal in case of acquittal is not in the section 376 of the CRPC. So it is not correctly matched. and reference to High Court is not in section 397 of the CRPC. So therefore these are the not correctly matched, and therefore the answer is A 3 1 3 4, and therefore the option B is correct here. Moving to the next question, let's see the next question of this UP 2006 question paper. Which of the following cannot who of the following cannot claim maintenance under section 125 clause 4 of the CRPC? The options which are given here: wife living in adultery, wife living separately by mutual consent, both A and B, either A or B. So who can't claim the maintenance under the CRPC? So the answers which you all need to see. So the both, when wife is living in adultery and when she is living separately by mutual consent, then in both the cases she can't claim the maintenance here. Okay. Coming to the next question. Save in exceptional circumstances, no woman shall be arrested after sunset and before sunrise where such exceptional circumstances to arrest exist. The woman police officer shall obtain the prior permission of the following. तो जब कभी भी वीमेन को अरेस्ट करना है, पहली बात वो सनसेट के बाद और सनराइज के पहले जो है वो उसको अरेस्ट नहीं कर सकते हैं, लेकिन एक्सेप्शनल केसेस में अरेस्ट कर सकते हैं. लेकिन किसकी परमिशन चाहिए? डिस्ट्रिक्ट मजिस्ट्रेट, सुप्रिटेंडेंट ऑफ पुलिस, judicial magistrate of first class, session judge. So give me the answer. The answer is the judicial magistrate of the first class. So in that case, exceptional case, you can arrest the woman even in case of the sunset is there and before the sunrise as well. So going to the next question, who among the following is not entitled to claim maintenance under section 125 of the CRPC? So who is not entitled? The options which are given: a divorced wife so long as she does not marry, unmarried sister, adoptive mother, illegitimate minor child. So who is not eligible to claim the maintenance? So just give your answers here. I am waiting for a response here for that. Yes, give your response. Yes, this unmarried sister is not covered. The rest of the people are covered under section 125 of the CRPC. So this is the correct answer. B. Option B is correct. When the High Court or any session judge calls for examine the record of any proceeding before any inferior criminal court, it is known as. So whenever High Court is calling or session judges is being called of examine the record of any proceeding before any inferior criminal court, it is being called as what kind of the proceeding? Give your answers here. I'm waiting for response. Yes, it is the revision. So it is not reference, it is not review, it is called as a revision. So this is how you can find that under the section 397 of the CRPC, where you can find this kind of the provision. Okay. Coming to the next question. A report of person arrested without warrant shall be given by the officer in charge of the police station. Okay. A report of person arrested without warrant shall be given by the officer in charge of police station. Only district magistrate, only sub-divisional magistrate, judicial magistrate of first class, either district magistrate or sub-divisional magistrate. So give the right answer here. Without warrant. Yes, the answer is either to district magistrate or sub-divisional magistrate. Okay. So the D is correct. Going to the next question. Next question. When a search is required to be conducted outside India, a criminal court may under section 166A of the CRPC issue. So whenever a search is required outside India, so whether what kind of the action would be taken, whether it would be search warrant, letter of requisition, letter of request, written order. So give your answer here immediately. Which is the right answer? It is about the letter of request. Okay. Going to the next question. Analytical positivism does not mean that. Now the questions are coming from the jurisprudence. Okay. Now here from you can see the questions are coming from the jurisprudence. Now analytical positivism does not mean that laws are in the nature of commands, laws as it is, and it ought to be have to be separated. Certain inherent moral quality is an essential feature of law. Its analysis of legal concept is distinct from critical evaluation. So now which is not a meaning within the analytical school here. So give your answer yes. So you all know that, my dear friends, analytical school never believes in the moral quality. So the option C is correct here. Nature has placed man under the empire of pleasure and pain. It has been said by whom? The options which are given: Bentham, Pound, Austin, and Hobbes. So which is the right answer? Give your answers here. Yes, the answer is the Bentham, who has written the following words: Law grows with the growth of the people, strengthens with the strength of people, and finally dies away as the nation loses its nationality. So you can see it is about more nationality, but it is about the people's association with the law. And the options which are given here: Hart, Bentham, Savigny, and Spencer. So who had said this one? Yes, the answer is Savigny, because he belongs to historical school. Who defined law as the desacralized command? The options which are given here: the Kelson, Bentham, Austin, and Salmond. So which is the right answer? That the law defined as a desacralized command? Yes, this is the answer is the Kelson had said so. Coming to the next question, the principal jurist of the philosophical school was Herbert Spencer, Sir Henry Maine, Max Weber, and Hegel. So who is the principal jurist of the philosophical school? Just give your answers here, waiting for a response. Yes, who is the principal jurist? The man is the Hegel. Going to the next question. Name the jurist who is called as Darwinian before Darwin and sociologist before sociologist. The options which are given here: Kelson, Pound, Savigny, Gray. So give your answers. I am waiting for a response here. Who is being called as Darwinian before Darwin? Yes, the man is Savigny. Now the next question: lawsuit continue to support minimum morality has been pleaded by whom? Lord Devlin, Leon Fuller, Hart, Dworkin. Who had said so? Give your answers here. Lawsuit continue to support minimum morality. So yes, the answer is Lord Devlin. Okay, he had said that it must continue to support minimum morality. However, Fuller had said that there is an inner morality of law. So there is a difference also. Lord Devlin said that it must continue support from the minimum morality. On the other side, Fuller had said that the all laws must have some inner morality here. So who said that ownership is a plenary control over an object? Okay, so now the options which are given: Hibbert, Holland, Austin, Salmond. So which is the right answer? You all can see the highlighted portion as well. So the right answer which is here, the Holland had said that ownership is a plenary control over an object. Going to the next question, the concept of living law was expounded by which jurist? Which jurist had said that it is a living law? Who has propounded this theory? So you can see here the options which are given in Austin, Ehrlich, Pound, and Holland. So which is the right answer? Just give your answer to the comments. Yes, the right answer is Ehrlich. Ehrlich has said that had given the concept of the living law. So this is how you can see here. Okay, moving to the next question, question number 100, which we are going to take here. Okay, you can see here. Who wrote that the only right which a man can possess is the right always to do his duty? Who was the man who had said so? Yes, you all know that the man is Duguid, who had said that there is always a duty to the man will always have a duty, not as a right. Okay, so you can see which one of the following is not a theory of legal personality. The options which are given here: in fiction theory, concession theory, interest theory, and the bracket theory. So which is the theory do not belong to legal personality? Yes, the right answer is the interest theory. Interest theory do not believes in the legal personality. Coming to the next one, how did Aristotle describe justice in restoring equality when this has been distributed? So the options which are given here: distributive justice, corrective justice, universal justice, and natural justice. So how did Aristotle describe justice in restoring equality? So the options which are given, I had told you, just give the answer. The answer is the corrective justice. Moving to the next question, in which one of the following cases the court pierced the wheel of corporate personality? Now let's see the options which are given: Solomon versus Solomon case, Smith, Stone and Knight case, Daimler Company versus Continental Tire Company case, People's Pleasure Park Company versus Rohilder case. So these are the options which are given here, and you all know that the right answer is Daimler Company versus Continental Tire Company. This is about the corporate personality. Okay, coming to the next question, analysis of the right into four juristic correlative was given. Who has given the four juristic correlatives? Dural postulates not. It is about juristic correlatives about the rights. Roscoe Pound, Radin, Hoffeld, and Kokriuk. Who is the right answer? Who is the man who had said so? Yes, the answer is Hoffeld. Hoffeld has given the juristic correlatives. That right belongs to, there is a opposite to right duty. So this is how you can find that. Which one of the following is not a correct classification of possession? Possession in fact and possession in law, mediate and immediate possession, corporeal and incorporeal possession, direct and indirect possession. So which is not the correct classification of the possession? Yes, the answer is direct and the indirect possession. Okay, so this is being called de facto and de jure also. Next question is from the international law. Now this question is very old one, and I hope that it will be not asked here. However, for the sake of answering this question, we are taking this question. The USA-led armed attack on Iraq in March 2003 was justified in international law, was necessary to destroy weapons of mass destruction founded by the UN team in self-defense of the USA. So, which is the right answer? Yes, it was not justified. Okay, which one of the following which one of the following signed the United Nations Convention on use of electronic communication in international contexts in September 2006? Again, this is a very old question. It is not going to us, so we are leaving this one. Who was the United Nations to consider the development of an international security monitoring presence in Lebanon? So again, this is a very contemporary question, so perhaps it would not be asked. And however, for the sake of the answer, the G8 leader had said so. General Assembly resolution of 15 March 2006 decided to establish the Human Rights Councils based in Geneva. So now, my dear friends, you can see the questions which are coming from the international law. They are more about the contemporary issues which are going on in the international law, or the globalization, or you can find that in international arena. So you all need to see the current affairs also for this one. Okay, so I'm not taking this one because this question deals with the 2006, and the paper is also of the 2006. So it is basically from the current affairs like that. Now this is another question which is also from the current affairs. Recently concluded mutual legal assistance treaty between India and the US relates to the area of trade and commerce law, oil exploration, open sky agreement, criminal law. So again, this is question from the current affairs. I'm not going to take this one, but however, it is belonging to criminal law for your reference. Asia Corporate Dialogue has been constituted for military assistance, economic cooperation, transportation, tourism. So for what purposes it was constituted? So you can see the options which are given here, and the right answer is economic cooperation. So you can find that this is another question from the Iran. That is how you can find the contemporary question. I am not dealing this one. Now this question number 113. It says that the World Trade Organization Agreement on Agriculture was to implement over a period of 6 years, beginning from 1995. Now it has been extended for developing countries. What is this period of extension? So this is also question for from the contemporary, or you can say the current affairs, but maybe it may be asked. So therefore, I am giving the right answer. The right answer is 10 years. Who has been elected recently as the next Secretary General of the United Nations? So it is no more question required for you here. Guantanamo Bay has an international notary for what reason? This is also a very old question. This was for the American Detention Center for Terror Suspects. However, it is no more required for this one, so I am crossing it. Then Volcker report deals with which one of the following case? Again, it is a the current affairs. So it was dealing with the Iraq's oil for food scandal, but no required to be mentioned here because it is an old question, not relevant. On which date India and US announced civil nuclear cooperation through the joint statement? Again, this is not required because it is old question, but answer is 18 July 2005. How many states are member of an international group IPSA, of which the first summit was held in September 2006? Again, for that you can learn this question, that is IPSA, and the options which are here: 10 states, 12 states, and 4 states. So you can see that you can remember this question only for the how many members were in the IPSA, but now it is the 2006, so it may have updated one. So you have to see. But at that time when it was there, it was about the 3 states. Okay, so it was India, Brazil, South Africa. Okay, IPSA means India, Brazil, and South Africa. So these are the 3 nations. Okay, in which country the 14 non-aligned summit was held? So again, this is contemporary. It is a current affair questions on the international arena. I will not take this one, but the answer was the Cuba. Portugal has extradited Abu Salem to India under which the following? So Indo-Portuguese extradition treaty or like that. So I'm not going to take this one again. So just going to question number 121. This is a question which may be asked because it is now provision based. So you can see here which article of the Union Charter relates to domestic jurisdiction. Article 2 clause 6, Article 23, Article 51, Article 72. So you can see the option is the Article 2 clause 7. Which article of the Union Charter provides for the expulsion of a member's state? Article 1 clause 2, Article 6, Article 48, Article 51. So you can see this is belonging to the expulsion of members from the Article 6. Okay, going to the next question. The budget of United Nations is approved by whom? By Security Council, by General Assembly, by Secretary General, Economic and Social Council. By which body it is going to approve the budget? Yes, it is by the General Assembly. Coming to the next question. The legality of the Uniting for Peace resolution of the General Assembly has been upheld by the International Court of Justice in certain expenses of the United Nations cases, condition of members in the United Nations case, military and paramilitary case, and repression case. So the legality of the Uniting for Peace resolution of the General Assembly has been upheld by the ICJ in this on the ground of that in the case of the certain expenses of the United Nations cases. Now next question. This is also important. The United Nations enjoy immunities and privileges in the territory of its member states under Article 20, 104, 105 of Charter, 106. So under which one? So the answer is under Article 105 of the Charter. So it enjoys privilege in the territory of its member states through the Article 105 of the Charter. Coming to the next question. Of which of the following international judicial institution the seat is not at the Hague? Hague में कौन सा judicial institution का seat नहीं है? The options which are given: International Criminal Court, International Court of Justice, Permanent Court of Arbitration, International Tribunal for the Law of the Sea. So the answer is International Tribunal for the Law of the Sea has no seat in the Hague. Okay, moving to the next question. Now let's see question number 127 here. The Permanent Court of Arbitration was established in pursuance of the following. Option A, Hague Conference of 1899 and 1907, Covenant of the Leagues of Nations, UN Charter, and none of the above. So the Permanent Court of Arbitration was established in pursuance of the Hague Conference of 1899 and 1907. Which one of the following is not specialized? Now coming to the next question. Which one of the following is not a specialized agency of the United Nations here? Universal Postal Union, United Nations Children Fund, International Civil Aviation Organization, International Financial Corporation. So this is another important question. It may be asked in your examination also. So the answer is International Financial Corporation. Moving to the next question. A non-member of the United Nations can become a member of the Statute of the International Court of Justice when? On the recommendation of General Assembly alone, on the recommendation of Security Council alone, on the condition to be laid down by General Assembly, on the recommendation of the Security Council, and the third last one, on the recommendation of the Secretary General. So a non-member of the United Nations can become a member of this ICJ when the condition to be laid has been laid down by Assembly has been fulfilled, and there is also recommendation by the Security Council. Then it can be possible. Again, on which date the General Assembly, again this is a question from the contemporary issues and it is old one, so we will not take this one. The optional clause in para 2 of Article 36 of Statute of International Court of Justice is related to what? So Article 36 clause 2 of the ICJ, it belongs to which kind of provision? Voluntary jurisdictions, compulsory jurisdictions, advisory jurisdictions, or the none of the above. So the answer is compulsory jurisdiction. In the event of a dispute as to whether the international court has jurisdiction or not, the matter shall be settled by whom? By Security Council, by the General Assembly, decision of the International Court of Justice, or none of the above. So, which is the right answer? Yes, it would be decided by the General Assembly. Not just, sorry, it is not by the General Assembly. It is by the this one, decision of the International Court of Justice. I am little bit in hurry because you can see all these questions which I am highlighting here. You can see here also, but not as much fast. Okay, which one of the following organization deals with the refugees? Okay, now let's see. UNESCO, UNHCR, SWAPO, EEC. So which is the a kind of the following organization deals with the refugee? Okay, so give your answers here. Which belongs to that one? Yes, the right answer is United Nations of Human Rights Council, that is UNHCR. Okay. Moving to the next question, which article of the UN Charter recognizes the right of individuals and collective self-defense to its members? Article 26, Article 51, Article 73, and Article 29. My dear friend, this is very important question, and this is Article 51. It allows the states to recognize the collective self-defense. Okay. Coming to the next question. That is very important. Who was the first Secretary General of the United Nations? Yes, the right answer is Trygve Lie. This is the right answer. Okay. Coming to the next question. Which one of the following is a directive principle of state policy? Now the questions are coming from the constitution here. So, is a directive principle of state policy to organize village panchayat, right to education, right to provide property, right to move Supreme Court? The answer is village panchayat. Now, next question. Article 21A of the right to education to all children of the age of 6 to 14 years has been inserted in the constitution by which amendment? It was inserted by the 86th amendment of the 2002. Coming to the next question, the doctrine of territorial nexus is related to which of the provision of the Indian Constitution? Article 13, 211, Article 300, and Article 245. The right answer is Article 245 of the Indian Constitution. Moving to the next question, in which article of the Constitution the eligibility for re-election of the president is given? Okay, Article 57, Article 58, Article 59, or Article 60? The answer is Article 57. Article 57 of the Indian Constitution. It has a provision with respect to the re-election here. Okay. Moving to the next one. A professor of university who is an eminent jurist is eligible to be appointed as judge of the High Court, both High Court and Supreme Court, neither Supreme Court or nor the High Court, only Supreme Court. Yes, the answer is only the Supreme Court. For that, you can refer the Article 124, Clause 3, Subclause C. Okay. The quorum for meeting of the House of Peoples. Yes, it is the House meeting is quorum is the 1/10 of the total members. If there is a 1/10 member of the house is present, then that is sufficient to have a meeting. Okay. Creamy layer rule excluding the well placed members of a caste from reservation was first laid down in the case of Ashok Kumar Thakur, Menka Gandhi, President of India, Indira Sahani versus Union of India, Minimum Mills versus Union of India. Yes, this is case of the Indira Sahani versus Union of India. In which case the Supreme Court directed the government to implement the law against female foeticide with full determination. So the options which are given here: Parent Association versus Union of India, Madhu Kishore versus State of Bihar. Yes, this is the right answer. Chehat versus Union of India. It is not the right answer. Nishi Maghu versus State of Jammu and Kashmir. It is also not the right answer. So in Madhu Kishore versus State of Bihar, the court had said that there is a need to have a law against the female foeticide. Going to the next question. Uh, After which one of the following Supreme Court decision was a special provision for social education backward class introduced by an amendment of the Constitution? Okay. सो किस जजमेंट के बाद सोशली एजुकेशनली बैकवर्ड क्लास का प्रोविजन इनेक्ट किया गया? यस, द आंसर इज स्टेट ऑफ मद्रास वर्सेस चंपाकम दुराइजराजन. गोइंग टू द नेक्स्ट क्वेश्चन विच इज बेस्ड ऑन assertion and reason, and this is this: right to education is a fundamental rights. Our constitution has no provision for education before making right to education as a fundamental rights, and these are the assertion has been and statement has been given here. Now coming to the support or the assertion and statement, yes, A is true but R is false. Already we had some provisions in DPSP with respect to making some rights as a fundamental right, and we had some judgments also. Coming to the next one, Atreus Fowler's acquit principle is related to what kind of the principle of the law? Retrospective operations, double jeopardy, ex post facto law, self-incrimination. So just see this and give me answer. Yes, it belongs to what kind of provisions? It belongs to double jeopardy. Which one of the following is the correct statement? Full faith and credit clause of the Constitution does not apply to public acts, public records, acts of corporation, judicial proceedings. So just give me the answer. Full faith and credit clause of the Constitution does not apply to which kind of the provisions of the Constitution? So give me the answer. Yes, the answer is acts of corporation. For this one, it applies. Public Record Act, Public Record, Judicial Proceeding. For that, it applies. Coming to the next question. When the two houses of parliament differs regarding a bill, then the deadlock is resolved by. जब दो हाउस आपस में बात नहीं करते हैं और काफ़ी कॉन्फ्लिक्ट होता है, बिल पास नहीं होता, तो क्या तरीका होता है? Yes, the answer is a joint sitting would be called here. Okay, and for that you can refer section 108 of the Indian Constitution. Moving to the next. Match list first and list 2 and select the correct answer using the codes given below the list here. Okay, now let's see. So India, that is Bharat, it is Union of States. Then the liberty of thought, expression of faith and belief. So India, that is Bharat, Union of States, it belongs to Union and Territory. That is 3. Liberty of thought, expression and worship, it belongs to the the preamble. And then the freedom of expression and the speech expression, it belongs to right to freedom. And protection of interest of minorities, it belongs to the culture. So if you see this one, you can find that the right answer is of this question is this C. Okay, that is 3, 1, 2, 4. Okay. Now at the end of this video, we are going to take the last question. So my dear friends, if you like this video and you want to more such video, please subscribe our channel so that we can have more questions on this judiciary, or on some other videos also we will have. So the question here: the law declared by Supreme Court of India is binding on all courts within the territory of India, but the Supreme Court is not bound by its decision. It was decided by Supreme Court in which case? So my dear friends, if you see, this was also a question which was asked in the 2003 year. Okay, now it was asked again in 2006. So therefore you can see the importance of the revision of the previous year question papers. Okay, so the options which are given here that is Keshwan Bharti versus State of Kerala, Indira Nehru Gandhi versus Raj Narayan, Madhav Rao Sindhya versus Union of India, and last Bengal Immunity Company Limited versus State of Bihar. So the right answer is Bengal Immunity Company Limited versus State of Bihar. So with this, here my dear friends, we are finishing the question paper of the 2006 of the prelims of the UP Judiciary for the law subject here. So please subscribe our channel, like and share with your friends, and thank you for watching the video, and do comment in the video so that we can make good video. So thank you again everyone. We will meet with another video in this series. Thank you.